This is part 28, and we will continue our discussion regarding culpable homicide amounting to murder, and culpable homicide not amounting to murder, by having reference to two sections, namely section 299 and section 300 of the Indian Penal Code. Now, three ingredients as far as section 299 with which you are dealt. With this, we also compare four ingredients as far as section 300 is concerned, and there we have learned it is the degree of probability that determines criminal liability. When the death is probable, when the court comes to the conclusion that the death was probable, liability is for the offence of culpable homicide. When it was most probable, liability is for the offence of culpable homicide amounting to murder. Or when there is likelihood of death, liability is for the offence of culpable homicide, and when there is certainty of death, liability is for the offence of culpable homicide amounting to murder. Now, if it happens that a person who causes bodily injury to another who is laboring under a disorder, disease or bodily infirmity, and thereby accelerates the death of that other, shall be deemed to have caused his death. So what is the meaning of this? The meaning of the first explanation to section 299 says, he shall be deemed to have caused his death, means it will be taken for granted that he has caused his death. Who has caused? A person who causes bodily injury. To whom? To another. And what is the person is such a person is laboring under a disorder, disease or bodily infirmity, and thereby accelerates the death of that other. So the death of the person was accelerated because he was laboring under a disorder, disease or bodily infirmity. So that cannot be a defense that, well, he was laboring under a disorder, disease or infirmity, hence that accelerated the death, cannot be a defense. Even though that has accelerated, the liability is for the offence of culpable. He shall be deemed to have caused the death. So he shall be responsible as far as the death is concerned, provided then the case falls under one of the ingredients. For example, as we have dealt, whoever caused, his intention must be to cause death. Secondly, whoever causes death by doing an act with the intention of causing death, or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely by such act to cause death, commit the offence of what is known as culpable homicide, he shall be deemed to have caused his death. Second explanation deals with the cases where it says that death is caused by bodily injury. The person who causes such bodily injury shall be deemed to have caused the death, although by resorting to proper remedies or the skillful treatment, the death might have been prevented. The person never resorted to proper remedies or skillful treatment which resulted into death cannot be a ground, he cannot be absolved of the criminal liability. He shall be deemed, the second explanation to say, where death is caused by bodily injury, the person who causes such bodily injury shall be deemed to have caused his death. In other words, the court will take it for granted he has caused his death, although by resorting to proper remedies or skillful treatment, provided the nature of the injury was caused which was likely to cause death of the person, as far as the second explanation to be read with. So don't read these explanations in isolation, independently in watertight compartment. Explanations are required to be read along with the ingredients of the section from the point of view of understanding the same, of which you should take serious note. With this now, if a woman is carrying a baby, is in her womb, and if she is pregnant and the kick is given on the abdomen, which resulted into death of the baby, what is liability of as far as the death of the baby is concerned? And this will not amount to culpable homicide for the simple reason. Third explanation to section 299 says, the causing of death of a child, in the mother's womb is not homicide. Causing of the death of a child in the mother's womb is not homicide, but it may amount to culpable homicide to cause the death of a living child if any part of that child has been brought forth, though the child may not have been bred or been completely born. So that is what is the effect of it. Let me tell you. If you start right from section 312 onwards, These are the sections which deal with miscarriage. And then this is required to be read with Medical Termination of Pregnancy Act, which was enacted in the year 1972 accordingly, with which if time permits and if it is necessary we will deal. But this is the provision. If you cause a death of a baby which is in the mother's womb, it is not homicide. How long? But it's not necessary that the child should have been bred or been completely born. It says it may amount to culpable homicide to cause the death of a living child if any part of that child has been brought forth, though the child may not have been bred or completely born. So these are the three explanations as far as section 300 299 of the Indian Penal Code is concerned. With this now we want to understand importance of these, though there is certainty of death. It is not only the certainty of death, but the state of the mind of an individual at the time of doing a particular act is required to be taken into consideration from the point of view of determining criminal liability. And then first of all, let us start with what? Let us start with few illustrations so that you will understand the distinction between, though there is certainty of death, culpable homicide amounting to murder and culpable homicide not amounting to murder. A case where a wife is undergoing last stage of the cancer and there is no remedy as such. The pains are unbearable, and such a wife has told her husband, "Please kill me because I cannot bear the pain." Husband takes out revolver, fired into her direction and kills the wife. What is liability of the husband? That is the question. And in the second situation, when he was not, he never kills wife with her consent, but he is fed up with the disease of the wife. Even though he is trying his best, the wife doesn't get satisfaction. Always she goes on complaining. So one day he takes a revolver and fire into direction of the wife. Same distance, same revolver, same part of the body, and that has resulted in death of the wife. What is the liability as far as the husband in the first situation is concerned, and the second situation is concerned, is the question for our consideration. Or the case where the husband came home, he went to the bedroom and he saw his wife with somebody else. He immediately took out revolver, fired into the direction of the wife, which resulted into death of the wife, is one situation. And then when he saw his wife with somebody else, he decided to leave the place he went, came after 5 years to the same place again and fired the wife. Is there any distinction? Same revolver, same distance, same part of the body, and there was, in both the cases there was certainty, but whether there is any distinction is the question. Or a person who was exercising, a person was exercising the right of private defense, and then also that is also one of the exceptions with which we shall be dealing. And then what he does at the time of exercising the right of private defense, he has exceeded the right of private defense. What is his liability? And when he had no right and he kills, and when he had a right and when he has exceeded, who is their distinction as far as criminal liability is concerned? Or the case where a public servant exceeds the powers which are given to him by law and kills somebody, what is his liability? That is also the question that we have to take into consideration. And then if there, A and B had a quarrel, first of all there was hot exchange of words, then there was hot exchange of blows, and one picked up a stone thrown into the direction of another, which resulted in the death of the person on the spot. What is the liability when there is when the death of the person has taken place? When, how, in a sudden fight, in heat of passion upon a sudden quarrel, without offenders having taken undue advantage or acted in cruel or unusual manner, what is the liability is the question for our consideration, has to be taken into consideration. Now, as we proceed further, in all these cases, there is certainty of death. But in a case where it falls under any one of the exception, and how many exceptions are there? There are 5 exceptions. And if the case falls under any one of these exceptions, liability of an individual is for the offense of culpable homicide not amounting to murder. And what is the first exception? First exception says, when culpable homicide is not murder. And it says, culpable homicide is not murder if the offender is deprived of the power of self-control by grave and sudden provocation and causes the death of the person who gave the provocation, or causes the death of any other person by mistake or accident. Now, if one person kills another person when he has lost his self-control by grave and sudden, it is not or, it is grave and sudden provocation. The provocation must be grave and the provocation must also be sudden. At times it may be a grave, but it may not be sudden. At times it may be, sudden, but it may not be grave. In that case, the person can then, this is the state of the mind. When you have lost your self-control because of the grave and sudden provocation, if you kill somebody, what is your liability? Your liability is for the offense of culpa. There is certainty of death. But even though there is certainty of death, it is the state of the mind that you have lost your self-control because of grave and sudden provocation, and hence your liability is for the offense of culpable homicide. You have got no right to end anybody's life. You have got no right to kill anybody. Forget about that. It is not for you. You can't, dare to take decision to end your life, because if you are successful, the matter ends there. But if you are unsuccessful, your liability is as per section 309 of the Indian Penal Code is concerned. So it's not that you can't, you can't kill others, you can't kill yourself also. That then if you have crossed the stage of the preparation, and that is what is known as narrative, there starts your liability. And then if you read the explanation, it says whether the provocation was grave and sudden enough to prevent the offense from amounting to murder is a question of fact. So this is, this will depend upon many factors. Whether when the husband has seen his wife that she is having relations with somebody, or there is confession on the part of the wife, that is vice versa also. Not only confession on the part of the wife, but there can be, if there is a confession on the part of the husband that he is having illicit relations with somebody, this is grave and sudden provocation. Now, what is grave and what is sudden? At times, when I told you husband saw his wife and fired, that was a grave and sudden provocation. But if if the husband comes after 5 years, it is grave but not at all sudden. And hence, whether the provocation was grave and sudden, so that the offense amounts to the offense of culpable homicide not amounting to murder, is a question of fact. And this, depends upon many factors. Whether the provocation, the social background, the economic background, the cultural background, the strata of life to which a person belongs. In one case, for example, when there was quarrel between two neighbors, and one neighbor was standing in front of the door of another neighbor by having his hands on the mustaches and staring at the person as if, what are you going to do? That was the look. It was held by the Supreme Court that is the amount to grave and sudden provocation. Yes, there are cases. Or for example, if there is one abuse also, the nature of the abuse that is given by one person to another person may lead to losing of self-control by grave and sudden provocation, taking into consideration the strata of society to which he belongs accordingly. So these are the factors. But then, even though we talk about grave and sudden provocation, this grave and sudden provocation, the above exception is subject to the following provisos. And what are the provisos? 1. It says that the provocation is not sought or voluntarily provoked by the offender as an excuse for killing or doing harm to any person. So it is not that the provocation is not sought or voluntarily provoked by the offender deliberately, so that my case, instead of falling under the offense of culpable homicide amounting to murder, it should fall under culpable homicide not amounting to murder. If he has sought if provocation is sought by him or voluntarily provoked by the offender, in that case, for example, this exception is not applicable. 2. That the provocation is not given by anything done in obedience to law or of a public servant in the lawful exercise of powers of such public servant. That is, I mean, whatever is done by the public servant. I mean, you may say that you had lost your self-control, but that cannot be a defense, because this proviso is subject to the above exception is subject to follow. This is second proviso. And thirdly, it says that the provocation is given by anything done in lawful exercise of the right of private defense. So whatever is done in the exercise of the right of private defense, if you say that you had lost your self-control because of grave and provocation, because he exercised the right of private defense, no, that cannot be an argument, and hence these are the three provisos which come into operation as far as the application of this is concerned. When it is not voluntarily, when it is not a voluntary provocation is not sought or voluntarily provoked by the offender. 2. The provocation is not given by anything done in obedience to law or by public servant in the lawful exercise of the powers of public servant. And thirdly, it says that the provocation is not given by anything done in the lawful exercise of the right of private defense. It is a question of fact, hence a relative term, depending upon many factors which will be taken into consideration by the court of law, and standard of grave and provocation is bound to vary as per individual as far as this is concerned. Namely, first exception, even though there is certainty of death, and if it is proved that offender had lost his self-control because of grave and sudden provocation, liability of an individual offender is for the offence of culpable homicide not amounting to murder. Do read the illustrations which are given, as a result of which it will be possible for you to have clarity as far as the understanding of this first exception is concerned. Now the second exception, it says culpable homicide is not murder if the offender, in the exercise in good faith of right of private defense of person or property, exceeds the powers given to him by law and causes the death of the person against whom he is exercising such right of defense without premeditation and without any intention of doing more harm than it is necessary for the purpose of such a defense. Now we will discuss this right of private defense. When the right of private defense commences, how long first of all, what is this right? When the right commences, how long it continues, when it ends, when it extends to the causing of death, and what are the restrictions or limitations with respect to this. Now, second exception to section 300 says, if a person has exceeded the right of private defense. So what he has done, his act has resulted, when he was exercising the right of private defense, his act has resulted into death of the person. Offender's act has resulted into death of the person. But now, if the offender can prove that he has exceeded the right of private defense, so now this is the time when, during course of time, when as far as the right of private defense of the body is concerned, we will read section 100, which tells you, or which is the enumeration, when the right of private defense of the body extends to the causing of death. If your case falls under section 100, you are not liable, because you have to read section 100 along with section 96. Or if you are exercising the right of private defense of the property, and if your case falls under section 103, naturally that will not amount to an offence, because 103 is required to be read with section 96, which says nothing is an offence which is done in the exercise of the right of private defense. Very correct. But now, if the case you had a right, no doubt about it. So first condition is that you must have a right. And while exercising the right, what you have done, you have exceeded the right. Exceeding right is an offence, mind well. And hence, I mean, right is not an absolute right. When we shall deal with section 99, we will take into consideration what are the limitations or restrictions with respect to this right, with which we shall be dealing as far as section 99 is concerned. So what the person has done, he was exercising the right of private defense. He has exceeded the right of private defense, and that exceeding of the right of private defense has resulted into death of the person without premeditation and without any intention of doing more harm than it is necessary for the purpose of defense. The liability of such a person is for the offence of culpable homicide not amounting to murder. Having right, exercising the right, and falling under section 100 or section 103, not liable. You don't have a right and you do an act, you are liable. And you have a right, but you have exceeded the right and you have caused death of somebody, your liability is for the offense of. So killing somebody when you were not exercising the right of private defense, and killing somebody when you were exercising the right of private defense makes a distinction as far as the liability for the offense of culpable homicide amounting to murder and culpable homicide not amounting to murder accordingly. With this now, we proceed to third explanation. And what is third explanation? Third exception says culpable homicide is not murder if the offender, being a public servant or aiding a public servant acting for the advancement of public justice, exceeds the powers given to him by law and causes the death by doing an act which he in good faith believes to be lawful and necessary for the due discharge of his duty as such public servant, and without ill will towards the person whose death is caused. So this is public servant. Who is public servant? In order to know who is public servant, again you will have to have reference back to general explanations, and you read section 21 where 12 categories are laid down. If the case of the person falls under any one of the 12 categories which are enumerated as far as section 21 is concerned, is what is known as public servant. And what is said? Public servant now, if he exceeds the powers which are given to him by law. And this is the time I can draw your attention to two situations as usual. A thief, after committing theft, was running away with the property. Inspector of police, namely public servant, wanted to arrest him and book the offender, but he was trying to run away. And as he started running away and the inspector came across such a situation that he may escape, inspector took out revolver and told him, "Stop, otherwise I will fire." The thief never stopped and inspector fired into his direction, which resulted into death of the thief. What is liability of the inspector is the question when his bullet has resulted into death of the thief. And in the second case, where a man who is accused of the offense of murder commits murder and he is running away and is also asked by the inspector to stop, he doesn't stop and inspector fires, what is his liability? Now this is power of the inspector to arrest a person, not to, I don't say to kill a person, certainly not. And for the purpose of when you shall be dealing, or when you will have reference simultaneously, if you have adopted this method of correlating. Now this is the time power of the inspector is to arrest, and hence in order to know the provisions regarding arrest, you have to start reading right from section 41 up to section 60 of the Criminal Procedure Code. Yes, you read that. And then out of which, when you want to know details regarding arrest, you read section 46. And when you read section 46 as far as subclause 3 of section 46 of the Criminal Procedure Code, the law which implements tells the mechanism to implement the substantive law. Yes. In that case, for example, when you read subclause 3, what is the maximum power that can be exercised from the point of view of effective arrest? And there you will learn, if the person is accused of an offense which is punishable with death or imprisonment for life, the right of the officer extends to the causing of death as far as effective arrest is concerned. Subclause 1 tells you what is arrest, how arrest can be effected. Subclause 2 tells you that he can resort to all means so that the person should not be allowed to run away. Yes, person should not be allowed to escape or evade the provisions of the arrest. Yes, and 3 is the maximum force. So now when the thief is running away and if the inspector has fired, which has resulted into death, theft is an offense which is neither punishable with death or nor imprisonment for life, and what we can say, inspector has exceeded the powers which were given to him by law. In case when the murderer is running away, yes, when the murderer is running away, in that case, mind well, he is not liable, because murder is an offense which is punishable with death or imprisonment for life, and as per subclause 3 of section 46, the right of the person from the point of view of effective arrest extends to the causing of death. Yes, that is so. And hence now, the cases where if a public servant exceeds the powers which are given to him by law, and there is no ill will on the part of the public servant toward the person whose death is caused. These, there are some other aspects that you can, understand as as you read third exception to section 300 of the Indian Penal Code. But in brief, you can say when somebody has exceeded the right of private defense, his liability is for the offense of culpable homicide not amounting to murder. Public servant, when he has exceeded the powers which are given to him by law, his liability is for the offense of culpable homicide not amounting to murder. With this now, the fourth exception says culpable homicide is not murder if it is committed without premeditation, in a sudden fight, in the heat of passion, upon a sudden quarrel, and without the offenders having taken undue advantage and acted in cruel or unusual manner. So there is a sudden quarrel, sudden fight, and then in sudden fight one person kills another person, and if it is proved that without the offender has not taken undue advantage or acted in cruel or unusual manner, as per his case falls under fourth exception. And the explanation says it is immaterial in such cases which party offers the provocation or commits the first assault. So that will not be taken into consideration. It will be only found whether it is committed without premeditation or not. If the death is result because there was no premeditation, whether it is in a sudden fight, whether it is in a heat of passion upon a sudden quarrel. So when there was a quarrel between two on the road, all of a sudden, one had taken money from another, there was a demand, this quarrel, hot exchange of words resulted into hot exchange of blows, and then one picked up a stone and threw into the direction of another, which resulted into his death. That such a situation, as there is no, as in such a case, there is no, he has not, the person, offender has not acted in unusual manner, he has not taken undue advantage, and he has not acted in cruel or unusual manner. Liability of the offender is for the offense of culpable homicide not amounting to murder. So when it is a cold-blooded murder, that is culpable homicide amounting to murder, which is required to be compared as far as the fourth exception to this section is concerned, namely section 300 of the Indian Penal Code. With this now, last exception says culpable homicide is not murder when the person whose death is caused, being the above age of 18 years, suffers death or takes the risk of death with his own consent. So if person is caused, now this is again the person who has given consent to his death is above 18 years of age, and it says culpable homicide is not murder when the person whose death is caused, being above the age of 18 years, suffers death or takes the risk of death with his own consent. Then even though somebody consents and says kill me, you can't kill him. And even if you kill him with his consent, when the consent is valid consent as far as section 90 is concerned, and here general age for consent is 12, but read last clause, unless the contrary appears in the context consent given by a person who is under 12 years of age. So it is not here 12 years, what is the age? Contrary is 18 years of age. So when the person, as in a case where I told you, when the wife is undergoing, the pains are unbearable, she is undergoing last stage of the cancer, and she tells husband, please kill me. And imagine a situation where husband kills his wife with her consent when she is above 18 years of age. Liability, husband is liable, and liability of the husband is for the offense of culpable homicide not amounting to murder. But if the husband kills wife when there is no chance of cure, and such without her consent, liability of the husband is for the offense of culpable homicide. In both the cases we say killing somebody with his consent, killing somebody without his consent. In both the cases there is certainty of death, but it is the state of the mind that determines. Killing somebody with his consent and killing somebody without his consent makes the distinction as far as the nature of the offense is concerned. As we have learned, murder is an aggravated form of culpable homicide, and hence when you talk about murder, mind well, every murder is a culpable homicide, but every culpable homicide is not murder. Now, if the person commits the offense of murder, section 302 says, whoever commits murder shall be punished with death or imprisonment for life and shall also be liable for fine. So this is punishment for murder is death. And then if the person commits the offense of culpable homicide not amounting to murder, section 304 says, whoever commits culpable homicide not amounting to murder shall be punished with imprisonment for life or imprisonment of either description for term which may extend to 10 years and shall also be liable to fine if the act by which the death is caused is done with the intention of causing death or causing of such bodily injury is likely to cause death. This is one part. And second part says, or with imprisonment of either description for term which may extend to 10 years or with fine or with both if the act by which the death act is done with the knowledge that it is likely to cause death but without any intention to cause death or to cause such bodily injury as is likely to cause death. So the liability may be for the offense of culpable homicide, punishment is as per section 302. If it is for the offense of culpable homicide or culpable homicide not amounting to murder, depending upon whether it falls under part 1 or part 2 as per section 300 and 304 of the Indian Penal Code is concerned, the punishment varies accordingly. Generally, I don't refer to the section dealing with punishment, but here you will understand if person is liable for the offense of murder, the maximum punishment that can be inflicted by the court of law is death penalty. But in case of culpable homicide not amounting to murder, it is never a death penalty accordingly. So this is in as you go on, as and when it is necessary, we will come back to this topic, no doubt about it. But otherwise, this by reading two sections, you try to understand what is culpable homicide, what is culpable homicide amounting to murder, and what is culpable homicide not amounting to murder. Read both the sections and try to understand three ingredients along with three explanations as per section 299 is concerned. Do read four ingredients as per section 300 of the Indian Penal Code is concerned, and do take into consideration 5 exceptions, so that along with the sections dealing with punishment, so you immediately come to know that it is the gravity of the offense that determines the quantum of the punishment that can be inflicted by the court of law accordingly. With this now, if A wants to kill Mr. B who is on the road, but B is not alone, B is along with C. Mr. A never wanted to kill Mr. C, but he wanted to kill Mr. B. He fired. By the time his bullet reaches, Mr. B and C have exchanged a position. So his bullet, instead of killing Mr. B, kills Mr. C. What is his liability? Can A come out with a defense and say, well, I had no intention to kill him, and as I had no intention to kill him, the question of liability doesn't arise, is the question for our consideration. And this is exactly, he is liable. But why he is liable? Because this explains what do you mean by transfer of malice or transmigration of motive, and the principle is laid down as far as section 301 is concerned. It says culpable homicide by causing death of a person other than the person whose death was intended, and says if a person by doing anything which he intends or knows to be likely to cause death commits culpable homicide by causing the death of any person whose death he neither intends nor knows himself to be likely to cause, the culpable homicide committed by the offender is of the description of which it would have been if he had caused the death of the person whose death he intended or knew himself to be likely to cause. So liability is the same. Whoever causes death by doing an act with the intention of causing death doesn't speak about death of a particular person, it is death of a human being accordingly. And hence now, this is the time where the two more sections, for example, if a person wanted to commit the offense of murder and he is not successful, his liability is as far as section 307 of the Indian Penal Code is concerned, which lays down punishment for attempt to commit murder, and section 308, attempt to commit culpable homicide, that is the punishment which can be inflicted if the punishment is not as per section 302, but if there is an attempt, it is as per section 307. If it is not as per section 304, and if there is an attempt, the punishment is as per section 308 of the Indian Penal Code is concerned. With this now, we intend to discuss two more sections. Section 304A of the Indian Penal Code, causing death by negligence, that is one section, and then section 304B of the Indian Penal Code, which defines the offense of dowry death, with which we will continue our discussion as far as our next